All right, welcome back. Let's continue the discussion on that Supreme Court verdict on the former governor of Abia State, Orji Uzor Kalu, who, by the way, is a leader in the Senate. He's a 7th senator, as a matter of fact, and with this decision of the Supreme Court, of course, he would resume his position in the Senate, where he is, I think, the chief whip. I'm now being joined on the program by Jiti Ogunye, who is a lawyer, to also expatiate more on this Supreme Court verdict. Thank you very much, sir, for joining us on the program, and he joins us via Skype anyway. What do you make of the judgment, sir?
Well, my general impression about the judgment is that it's a very shocking judgment.
But is it shocking? Didn't you see this coming? And then the reasons given by the Supreme Court, all 7 justices actually, it was a unanimous judgment, so to speak.
Regardless, a unanimous judgment does not mean a judgment that cannot be critiqued. Unanimity of judgment does not necessarily underscore its infallibility or that judgment is sacrosanct. Granted that we're talking about the apex court.
But legally speaking, was it the right decision?
We're talking about the apex court. Once it rules and once it decides, of course, we're talking about the finality of litigation or adjudication, as the case may be. So, to that extent, we consider that we're talking about the final judicial bus stop here. But that doesn't mean that that judgment cannot be critiqued as Nigerians have the liberty to do. I've always maintained the view that just like a piece of legislation that can be commented upon, that can be criticized, or an executive decision that can be criticized, a judicial decision coming from the third arm of government is also a product that can be criticized. And so when some of our colleagues say that the Supreme Court has decided, you cannot comment on it, I say, no, that's not part of our law. You can, otherwise, we won't have what is called case review in learned journals. And of course, the world is moving. In the past, we didn't have television, we didn't have Skype, we didn't have all these things. And so we have to do all these things in journals. But now we have all these benefits of modern day technology. And so you can make your comment on it. So I was shocked. And what led to my shock was that we're talking about a legislation, and here we're talking about the Administration of Criminal Justice Act. When that legislation came in 2015, it was widely celebrated as being innovative, creative, and imaginative. And in particular, because I want to focus on the subject, the provision of Section 396 of Section 7 was celebrated by everybody. And what does the provision say? It says that a justice of the High Court or a trial court who is elevated can come back to conclude his work so that we will no longer have the incidence of cases starting de novo only for reason of elevation of the judex. And many people say that, this is very innovative and that it is not only in this jurisdiction that you are going to have this kind of innovation. Mind you, there have been cases that were truncated only because of the elevation of justices. EFCC was prosecuting Mr. Akingbola of Intercontinental Bank, and Justice Abiru was the judge in Ikeja here, Ikeja High Court. of the High Court of Lagos State. And trial had been concluded. It was judgment that was being awaited. And boom, there was an elevation. And that case could not be concluded. And that case later went on and on and on. And then eventually now, the Supreme Court said that the matter should be started afresh. That was the mischief that provision was meant to cure. And so there was a trial in this Orji Uzor Kalu's case. And mind you, we're talking about an attempt that has been made by the law enforcement agency, the anti-corruption agency, since 2007. So we're talking about a 13-year travail of justice here. The matter had gone up and down before going to the Supreme Court and on the issue of jurisdiction, before the matter then came back for trial and conclusion. And that Justice Dreams was elevated to the Court of Appeal. And the Court of Appeal gave a fiat, gave an authorization that it could go back to conclude that judgment. And it did. And now, phenomenally, the appeal had reached the Supreme Court, and the Supreme Court rendered its judgment today. My view is that that provision is not unconstitutional. There may be lawyers...
Is it not unconstitutional? Because the Constitution is pretty clear. Isn't the Constitution pretty clear on this? And should the fiat of the President of the Court of Appeal supersede that section of the Constitution that actually goes against this?
DEJI, I'm a lawyer. All the justices who decided this matter, with profound respect to them, were first lawyers before they became justices. And I'm telling you, there is no provision in the Constitution that specifically prohibits what was done in that case. I challenge any lawyer in Nigeria to come out and say that there is a section of the Constitution that says that no justice of the Court of Appeal.
But what about the provision that says that a judge of that a federal high court would be deemed to have been constituted if it's composed of at least a judge of that court?
Yes. That's what the Constitution says.
Okay.
But the same Constitution provides that by an act of the National Assembly, provision can be made to regulate practice and procedure of the court. The law we are talking about is an act of the National Assembly. And that law was not made by the National Assembly without realization that there is a constitution. So the conflict that is being invented, with due respect, that is being conjured up, there is no such conflict. And that's why I'm challenging anybody to say that there is a clear-cut provision that says that upon elevation, you cannot do it. Look, the Administration of Criminal Justice Act is an act of the National Assembly. The Federal High Court Act is an act of the National Assembly. The Constitution is deemed to have been made by the National Assembly. And time again, they amend the provisions of this Constitution. I'm submitting that that provision is too important to our administration of justice for any lashing to technicality to nullify that provision. That provision is a very useful provision. Look, cases go on for donkey years, 3, 4, 5 years. And judges are elevated. Or is it now going to be a rule of law that judges in the High Court that are trying criminal cases should no longer be elevated. And once they are elevated, all the cases they are doing will then have to start afresh. This is not. Look, we need to be constructive about justice delivery. Look, there are many decisions of our apex court castigating constant resort to technicality, thereby defeating the essence of justice. It is the same Supreme Court that castigates that the triumph of technicality over substantial justice is not something that should be celebrated. That technicality should not be elevated over and above the need to do substantial justice. And if you are to ask me, what prejudice has been suffered? The Constitution provides that from the conclusion of a case and the delivery, the conclusion of the case and final addresses in the case, a judgment must be rendered within 3 months. But the Constitution then says that even if the judgment is not rendered within 3 months, if you are now appealing on it, that judgment will not be rendered within 3 months that will be prescribed by the Constitution, that unless you are able to show that a miscarriage of justice has been done, that judgment will not be nullified on that basis alone. So in this case, what was the miscarriage of justice? Here. So how justice that I was tried by a judge who had been adjudicating the case all this while. He had been elevated. So I therefore ought not to have been tried further. Is that a miscarriage of justice? Look, that provision is too important. That's my point. I'm not even talking about Orji Uzor Kalu or whatever, that the Supreme Court didn't look at the reason why that provision was made.
So what's the way out of what's the way out of this now? I mean, the deed has been done. The deed has been done. What's the way to remedy this situation now? Would you be suggesting an amendment of the Constitution so that it
there is nothing to be amended. There is nothing to be amended in the Constitution. Look, what is going on? Is it
the AC? Is it the ACJ Act now that needs to be amended? The Administration of Criminal Justice Act. That section, does it need to be amended?
It doesn't need any amendment. It's an innovative provision that ought not to have been nullified. That's my submission. Look, it cannot be right.
Now, the reason I'm asking you this now is because what the Supreme Court has done now is to set a precedent. So if such a situation were to come up in the future, this case would be cited.
Exactly. That's the point I'm making. Exactly. And that's why when the apex court wants to take this decision, they should think of the long-term implication. They should rule for posterity, not just for the immediate. That's the point I'm making. The provision is too important to be nullified in that fashion. And I'm saying, what's the argument? The argument here is that once a judge is elevated and he takes the oath of office as a court of that appellate court, he can no longer be a judge of the High Court. Now, look at the other side. That judge cannot sit alone in the Court of Appeal. The provision of the Constitution says that the court will be constituted when no less than 3 justices sit on the case. So those who made that provision knew that that judge couldn't act alone in the Court of Appeal as a judge. So all these technical manipulation is unnecessary. He was the one who started the case.
But it's also quite odd to have the same judge, to have a judge at who hears a case at the stage of the High Court. You still have that same judge, even if he didn't hear that case, but you still have him at the appeal court as well. Isn't that odd?
There's nothing odd about the matter. The only thing is that he cannot then sit on the matter in the Court of Appeal. Look, you assume that those judges are in the Court of Appeal, or the head of the Court of Appeal, Mukashiwa, at that time, who gave that fiat in accordance with that provision. She didn't know the law.
Yeah, that's a good question.
Look. I'm saying that this kind of the Supreme Court, the justices, and lawyers will praise them because that's what we do. This judgment is a well-researched, well-delivered, that's what lawyers do. But I'm telling you that provision was innovative. The Administration of Criminal Justice Act came to expedite our laborious and our lethargic criminal justice administration. That it was a policy legislation. Those who made the legislation knew what they were doing. So they knew that a justice of the Court of Appeal, ordinarily had become a justice of the Court of Appeal and ought not to come back, but it was deliberately implanted. And I'm telling you that there is no provision in the Constitution that clearly prohibits it. All the provisions are in the Constitution is that, okay, well, if you have took the oath as a court of an appellate court, you can't straddle, you can't come back. But the law allows that. That provision made by the National Assembly allows that. The provisions of the Constitution allow the heads of the court to make use of court and allow the National Assembly to legislate on practice and procedure. And this is about practice and procedure, criminal law practice. And a Supreme Court then came further and said, no, it's in conflict with the provision of the Constitution. What's the conflict here? I can't see any conflict. What's the prejudice? I can't see. What's the fair hearing violation? I can't see. But 7 justices of the Supreme Court saw it, and that's the judgment. And Nigerians will be bound by it. And don't mind me. We are doomed. We are doomed to be citing this now as a precedent in the court tomorrow because that's the new law. But
it's exactly
I'm telling you, it's not. Do you know the adjudicatory and the prosecutorial labor that went into this? You think it is easy?
Not
you
at
think
all.
it's easy to prosecute successfully a politician in Nigeria who has a deep purse? Come on. You think it is easy? And so 13 years of labor went up in smoke. And so Nigerians are supposed to be happy now and clap and say that, yes, justice has been done. Justice has been done. Is that how justice is done? And there are even other aspects of this matter. I suspect now that on the strength of that judgment now, the person we're talking about will be released from prison custody.
Obviously.
But query. How do you release somebody from prison custody without a warrant of release? Without a release warrant? Specifically. Not just a judgment.
No, but in this case, do you need a release warrant? I mean, since the Supreme Court has said, look, the whole process was flawed, so it means you're going back to square one. So why do you need a release warrant?
Yes, that's the travel of justice and the rule of law. And I'm citing Chief Obama wrote a book, The Travels of Democracy and the Rule of Law. I call this The Travels of Justice and the Rule of Law.
Thank you very much for talking to us.
Yes, my pleasure. Thank you
so very much. Well, that's it on the program, but if you want to watch it again, it's very simple. Just go to our website, tv360nigeria.com. You'll find this program and lots more there. You can also follow us on our various social media platforms. Thank you very much for watching. I'll see you again next week. Bye-bye.